Hello, and welcome to this month's edition of The Legal Scoop. This is episode 3 of our web series where we discuss some notable wins here at LOMAD. Today I'm joined by Vicki Buehler, an associate attorney with the Law Office of Melissa Day, who's going to talk about a win that she had involving labor market attachment. So say hello, Vicki.
Hello, thanks for having me on.
Thank you, and we're glad to have you. Briefly, before we get into the details of your case, I'd just like to go over kind of the basic premise and tenets of labor market attachment. So obviously, with labor market attachment, it's where someone is less than totally disabled, and we argue that they should either be at work or looking for work. Would you mind just enlightening everyone who may not be familiar with just the basic standard of labor market attachment?
Yeah, so the case that we all turn to when it comes to labor market is American Axle. And American Axle basically says that there's a bunch of ways a claimant can look for work. They can go to Workforce, they can go to what's now Access VR, or they can do their own independent job search. But it has to be a timely, persistent, and diligent job search effort. So it can't be like, I called and looked for work. That's not good enough.
And then on top of that, it has to be within their restrictions. And it can't just be, I applied for absolutely every job in the want ads. It has to be something that the claimant is capable of doing per their doctor or per a decision on what their actual restrictions are. So I want to go into the details of your case. So could you just give me some of the basic background?
Yeah, so I had a claimant who was actually classified with a 66.67% loss of wage earning capacity. He was found to have a sedentary work capacity. So that basically means sit down type work. It means ability to stand and sit as needed, usually about a 10-pound lift and carry restriction. So pretty limited. Furthermore, this guy only speaks Bosnian. He testified that he has a very, very limited ability to speak, read, or write English. So really, he's a native Bosnian speaker. He really functionally has no ability to do English. So of course, that is going to play in pretty hard to any job search he does. A lot of judges are probably a little bit more lenient in that case. He had been looking for work since February. It was pretty consistent on its face. He'd been applying to about 4 to 5 jobs per week, which is usually about what a judge wants to see. And he had applied to Vested. He actually had a letter from them that said they couldn't help him. Although the fun part of that letter, and we'll get back to that in a second, is they did put a limitation on that. And then the other thing he'd done that was smart was he had attached the confirmation emails where he had applied on Indeed, and they send out the confirmation emails that say, hey, yes, an application was submitted. So on its face, this actually looked like a pretty good job search. But if you actually start looking at it, the holes popped up pretty fast. So back to that letter from Vested. Usually if you got a letter from Vested Access VR that says we can't help you, that's usually really bad for us because that means there's no retraining. They can't help with any job searches. Judges will often look at that and say, this right here is enough.
And just to jump in for a second, that's one of the ways that labor market attachment can be proved is to say that you reached out to some sort of rehabilitation service, usually Access VR, and you're either actively participating with them through some sort of retraining program, or like you said in this case, they flat out told you that they can't help you.
Yes. Now, the caveat here, though, was they said in the letter, we suggest you go take English language classes and therefore increase your ability to go find work. So basically, what I argued is they were not saying you can't do anything at all with these restrictions. They were saying, go learn English as a second language, take classes, add to your ability, and then come back to us. So that was different than just a flat out, we can never help you ever, which is, of course, what his attorney was arguing this stood for. The other thing was that these job searches, the jobs he applied to, were all over the place. He was applying to factory work. He was applying to a bunch of different sales positions. He actually applied, believe it or not, to be a dental hygienist. which goes to what you were saying earlier. You got to be able to apply to jobs that you can actually go do. He clearly didn't have any training for that. So when you actually started looking at the job search and not just the sheer amount of jobs that he'd applied for, there were some pretty big flaws. I mean, if you don't speak English, how are you going to do sales work? If you can lift 10 pounds and you're sitting most of the time, how are you going to go do assembly work?
That's great. So bringing it all home, I'm assuming you took testimony in this case, right?
We did, and once he started to ask questions about, okay, how could you actually go do this? Do you even know what these jobs involve? He started admitting that he had no idea what they involved, and he was just applying to everything he saw because he'd been told to apply to work. So that right there was pretty much enough for the judge. His attorney, of course, argued that he had been looking since February. He had the letter from Access VR. He should be found, essentially reattached, and award should begin. And we, of course, said absolutely not. This is in no way sufficient. He even admitted as much. He has no intention of actually working. And the judge agreed with us reluctantly, but she did agree with us. And so his awards have continued to be suspended. There's been a finding of no labor market attachment again.
Wow. Well, congratulations, Vicki. That's a really great win. And I think it's sort of illustrative of how sometimes you might look at a labor market case or have a labor market trial coming up, and you look at the proofs, and the judge might look at the proofs and just sort of think, yeah, this is good enough. There's plenty here. And you kind of might have, an inclination to just sort of roll over. But in this case, and, here at LOMAD, we always look at them very closely. There's a lot of things, ways to attack labor market, diligent, persistent, within your restrictions, active participation. All of these things are ammunition for us to sort of attack what seem to be perfect labor market attachment proofs. And, I commend you for, going the extra mile in this case and being able to get a win where it seemed like you had no chance. So thank you for coming on today and just sort of giving everyone an idea of what they should look for. If you have a case involving labor market attachment, you've got these job search records, give us a call, and hopefully we can take a look at it and sort of really assess the true value of those labor market proofs and see if we have an argument for suspension or for benefits not being continued.
Exactly. Thank you.